Before I begin the formal part of my speech, you can see that I've surrounded myself with a Praetorian Guard, just in case. It's very good to see so many people attending this event. I've always been extremely grateful for the interest that everyone has shown in this inquiry, not least, of course, the people most directly affected. But there's been a wider interest as well, and I'm very grateful for that. And so I wanted to start what I have to say by thanking everyone publicly for participating in the inquiry so far. Now, those of you with good memories may remember that I've made video-recorded speeches about aspects of the work of the inquiry on 2 occasions. The first video was made available as long ago as the 30th of September 2022, shortly before Phase 2 of the inquiry got going. The second became available on the 17th of July 2023, the day my interim report was laid before Parliament. In each of those videos, I emphasized the importance of 2 strands of investigation which were inextricably linked and which would be crucial parts of the work of the inquiry. Those strands were: 1, discovering and explaining the nature and extent of the adverse consequences suffered by so many as a result of the misplaced reliance upon the dependability and accuracy of Horizon, what we've come to call in this inquiry the human impact. And 2, discovering and assessing whether the Department for Business and Trade and the Post Office had made good or were making good upon the often repeated assurances from ministers, departmental officials, and senior personnel within the Post Office that financial redress for those who had suffered adverse consequences would be full, fair, and prompt. Over the nearly 3 years since I first highlighted those strands of investigation, nothing has occurred which has led me to change my view of their importance. It should come as no surprise, therefore, to those who have been following the progress of the inquiry that as soon as I had completed the oral evidence gathering phases, I turned my mind to whether I should deal with the issues of human impact and redress as part of a much larger report, or whether I should produce a part of my report, Volume 1, dealing discreetly with human impact and redress as soon as it was written. As will now be obvious, I chose the latter course. I chose this path because it is essential, in my view, that I provide a detailed report about the schemes which have been developed to deliver financial redress as soon as I reasonably could. That way, I would be able to report upon how they had performed historically and also attempt to predict how they were likely to perform going forward. Having heard and read a very substantial amount of evidence, I concluded that some aspects of the schemes could be improved substantially. In those circumstances, it made no sense for me to wait until the whole of my report had been completed and was ready for publication before revealing my views. However, I was also firmly of the view that a report which considered and reached conclusions about the schemes without first describing the adverse consequences which gave rise to the need for redress would be sadly lacking in context. I appreciate, of course, that much has been written and said about the adverse consequences suffered by postmasters and others over the last 25 plus years. Nonetheless, in the early months of 2022, I heard sworn evidence from a large number of people who allowed themselves to be questioned about deeply personal issues in the full glare of a statutory public inquiry. Throughout the whole length of the inquiry, I have received written evidence and other sources of information about the nature and scale of the human impact visited upon so many. The picture which has emerged is profoundly disturbing. It would have been wholly wrong of me to present this volume of my report without describing in some detail the human suffering which has given rise to the need for complex schemes for providing financial redress to those who have been wronged. Let me turn then to describe what this volume contains for those of you who have not yet seen it. Following an introduction, I list my recommendations. The introduction and the list are sections 1 and 2 respectively. Section 3 is devoted to human impact. It has 3 subsections: a short introduction, a summary of the main types of impact suffered by the various categories of people who are adversely affected, and then there are 17 case illustrations, which I chose because it seemed to me that between them they provided a cogent basis for all or virtually all of the adverse consequences which I'd already described. I acknowledge the possibility that the case illustrations may contain the odd factual inaccuracy. I say that because in the main, they are based upon the recollections of persons who are seeking to describe events which had occurred many years ago and often without contemporaneous documents to prompt their memories. But such inaccuracies as exist do not matter. The case illustrations are intended to paint a very broad but compelling picture of the type of harm which very many people have suffered. I am completely satisfied that they achieve that purpose. As I have said once already, but I repeat, the picture which has emerged and which is described in my report is profoundly disturbing. In summary, what does that picture reveal? Many thousands of people have suffered serious financial detriment, and for a sizable proportion, that detriment subsists. Many people have inevitably suffered emotional turmoil and significant stress in consequence. Many businesses and homes have been lost. Bankruptcies have occurred. Marriage and families have been wrecked. Between 2000 and 2013 in England and Wales, and for some time after 2013 in Northern Ireland and Scotland, postmasters and others suffered the trauma of criminal prosecution, conviction, and punishment. And for some, punishment meant lengthy periods of imprisonment. I received reports that some people held liable for shortfalls became ill as a consequence. Tragically, I heard too of people of whom it is said that they were driven to take their own lives. Section 4 is a very long and detailed section which contains a summary of the evidence which I heard and read relating to redress. I readily acknowledge that it is a difficult read for all except the most committed. It deals primarily with the schemes which have evolved for delivering financial redress to those who are entitled to it, but also covers other discrete issues which relate to financial redress. The section ends with a short section on restorative justice, a concept with which I was unfamiliar until it was introduced to me in this inquiry. In Section 5, I identify those core participants from whom I have received written and oral submissions about financial and other forms of redress. And then we have Section 6, which contains my conclusions and recommendations. Early on in that section, I pose the following question. Have the Post Office, the Department and ministers delivered financial redress to claimants which is full and fair, and have they done so promptly? In much of the remainder of that section, I set out my answers to all the component parts of that question. Before spending a few minutes summarizing some of those answers, however, let me explain how Section 6 begins. No more than a few lines have gone by before I make my first recommendation. And that says this: His Majesty's Government and or the Department, and where appropriate the Post Office and Fujitsu, shall provide written responses to my recommendations by the 10th of October, 2025. Some may think this recommendation is some kind of challenge to the government in general, the department in particular, the Post Office and Fujitsu. It is not. Rather, I categorize it more in the nature of a plea by me to all those who need to make decisions about my remaining recommendations to do so as quickly as they can. It would not be appropriate, in my view, to kick the can down the road and wait for the remainder of my report before deciding about whether to accept my recommendations. I suggest that a period of 3 months in order to make a decision about whether to accept or reject them is quite sufficient in all the circumstances. All the recommendations formulated, except that first recommendation, and numbers 17 and 19, are concerned with the schemes for financial redress. If my recommendations are to have their maximum effect, decisions about recommendations 2 to 16 and 18 must be made swiftly, and if, as I hope, of course, the recommendations are accepted, the sooner they are implemented, the better. What are some of the conclusions that I have reached about the schemes for providing financial redress? This is a thumbnail sketch. I'm afraid if you want the real meat of it, you will have to read Section 6. I'm going to deal with each scheme in turn and quite shortly. First of all, the Horizon Shortfall Scheme. This scheme has always been administered and delivered by the Post Office, although to a degree the department has pulled some strings too. Between May 2020 and the 30th of July 2024, all claims were assessed. The picture which emerges in relation to settlement within that period is as follows. A high percentage of the most modest claims were settled for the sums which were claimed, or for sums very close to those which were claimed. Whether some of those settlements were in reality full and fair can only be a matter of conjecture. Many claims in the brackets 20,000 to 60,000 were likely assessed at sums which were not full and fair. On the available evidence, I cannot confirm that a majority of high-value claims, which were resolved on or before that date, the 31st of July 2024, were settled for sums which were full and fair. On any view, many of the larger claims have proved very difficult to settle. To illustrate that point, as of the 30th of January of this year, there were 314 claims which had been submitted between May 2020 and the 27th of November 2020, but had still not been settled. A large proportion of those claims have been and continue to be very difficult to resolve because of their complexity and potential value. A fixed sum offer of £75,000 has been available to claimants since the 31st of July 2024. A significant number of claimants have opted to accept that sum. It is widely acknowledged that some of those claimants will have received sums which exceed the true value of their claims. It is as yet unclear whether the claims which have been assessed since the 31st of July 2024 have resulted in settlements which it would be proper to categorise as full and fair. As of the 30th of April of this year, HSS, as I'll use the acronym for shorthand form, had received 9,437 eligible claims, 6,644 offers had been made, and 5,812 had been accepted. Those in my legal team who assist me to keep track of recent events have discovered that HSS had received a total of 887 eligible claims by early June. There had been 7,188 offers and 6,426 acceptances. There are still more than 3,000 claims to resolve, and the likelihood is that there are approximately 1,500 complex and standard claims which are either in the process of assessment or waiting for the process to begin. In my view, if HSS is closed, as I recommend it should be, on the 27th of November of this year, a number of years would still be necessary to deal with all the claims which would be unresolved on that date. On any view, there have been egregious delays in HSS for which the Post Office and the Department have frequently apologised. The overturned conviction scheme and the more recently announced Horizon Conviction Redress scheme. Until the 3rd of January, OCS, as I call the overturned conviction scheme, was administered and delivered by the Post Office. 111 persons have had their convictions quashed by the courts and are eligible for financial redress. 3 persons who were prosecuted but not convicted are also eligible for redress under this scheme. It opened in July 2021, following the quashing of convictions in December 2020 at the Southwark Crown Court and in April 2021 at the Court of Appeal Criminal Division. Interim payments were made promptly to those whose convictions were quashed, except for 3 claimants who were denied interim payments, unfairly, in my view, on what was described as public interest grounds. Between the opening of the scheme and the publication of my interim report in July 2023, there were a number of partial settlements, especially relating to non-pecuniary losses, but there had been no more than a handful of settlements of both pecuniary and non-pecuniary losses. In September 2023, a fixed sum offer of £600,000 became available to those in this scheme whose convictions had been quashed. I understand the current position to be that 71 claims have been settled in full, 62 claimants have accepted the fixed sum offer of £600,000, and 9 claimants have had their claims assessed and accepted offers in settlement following assessment. That figure includes 1 claimant who was prosecuted but not convicted. 13 claimants have yet to submit particularized claims, and the remaining claims are in various stages of partial settlement or negotiation. It is impossible for me to tell you whether the settlements so far achieved can be categorized as full and fair, since I have not thought it appropriate to compel evidence from individuals about their settlements, and very little information has been volunteered by the claimants, who obviously value their privacy. The more recent scheme, which I'll call HCRS, was constituted as a discrete scheme administered and delivered by the Department in July 2024. It was set up to deliver redress to those whose convictions were quashed by legislation. The fixed sum offer of £600,000 has been a feature of HCRS from its inception, and so far as I am aware, all claimants whose claims have been settled, or at least who settled prior to the 3rd of June 2025, opted to accept the fixed sum offer. On the 3rd of June 2025, the overturned conviction scheme was amalgamated with HCRS. From the date of amalgamation, the scheme has been administered by the and delivered by the Department. The amalgamation of those 2 schemes was obviously sensible, which I suppose begs the question: why were there ever 2 distinct schemes for claimants whose convictions had been quashed? One operated and delivered by the Post Office, and one operated and delivered by the Department. OCS has not been without unjustified delay. The time taken to formulate pecuniary principles was described as a tortuous process. That is, in plain English, it took far too long. Furthermore, the process to formulate those principles did not begin until approximately 18 months after the scheme had been announced. The Group Litigation Order Scheme, GLOS, was set up to provide financial redress to those claimants who had been party to the group litigation brought against the Post Office and which was settled in late 2019. As is now well known, the claimants in the litigation appear to have won a famous victory. Unfortunately, the compensation they received under the deed of settlement did not properly reflect their losses. After a period of reflection, the government of the day agreed to provide funds so that additional financial redress could be made to those claimants. The scheme was announced in March 2022. Unfortunately, a year went by after the announcement before the scheme was opened. It has always been administered and delivered by the Department. There are potentially 492 claimants. By the 30th of April of this year, the number of fully particularized claims submitted to the Department stood at 450. 445 offers had been made, of which 304 had been accepted. 42 claimants had not submitted their claims. By my reckoning, as of the 30th of April 2025, there were 146 claims unresolved. My team tell me that at least 4 further claimants have submitted particularized claims by early June, but that would still leave 38 claimants who have yet to start the process of presenting a claim. A fixed sum offer of £75,000 was introduced in this scheme in January 2024. Of the 304 claimants who had accepted their offers by the 30th of April 2025, approximately 50% opted to accept the fixed sum offer, with obviously the same percentage or thereabouts opting for assessment. I have received no information about individual settlements, although I have been made aware that a number of claimants have expressed their unhappiness with the level of offers made to them. You should know that people continue to correspond with me right up until very recently about these matters. The likelihood is that most, if not all, of the claims which are unresolved are to be assessed. That means, in my view, that there is a great deal of work to be done if these cases are to be resolved satisfactorily within any kind of reasonable timescale. I say that because it appears clear that in many cases in which assessment is taking place, the valuations placed upon the claims by the claimants and their advisors, on the one hand, and the departments and its advisors on the other, is markedly different. I would like to emphasize that a number of recommendations which I make are aimed at removing some of the obstacles which currently exist along the path to achieving settlements which are full and fair. Even if the recommendations are accepted and implemented swiftly, however, it is difficult to imagine that the unresolved cases can be settled anytime soon. I am loath to predict when all the claims in that scheme will be resolved, but I very much doubt whether settlements of every claim can be achieved before the end of next year. To repeat, there are likely to be 150 claims or thereabouts in the process of assessment, which is a large number still. There is one last point which I wish to stress about each scheme. Although it is correct to say that the schemes are administered and delivered by either the post office or the department, everyone should understand that the persons who ultimately decide upon the awards to be made to claimants are not employees of the post office or the department. In both HSS and the group litigation scheme, the ultimate decision makers are independently appointed panels of appropriate experts. If their decisions are flawed, there is an entitlement to seek a review before a very experienced retired judge. In fact, there are 2 judges, one for each scheme. Those whose convictions have been quashed, that is, the claimants in OCS and HCRS, are not obliged to accept offers made to them by the department. They have preserved rights to seek redress in the courts. I turn finally to say something about my recommendations. Recommendations 2 to 16 all relate to the existing financial redress schemes. They are all intended to improve these schemes, but I readily accept that even if my recommendations are accepted and implemented as quickly as I would like, they will not constitute some magic formula for removing all of the problems from which the schemes suffer. As my report makes clear, I am critical of the Post Office and the Department in relation to the development and evolution of these schemes in a number of important respects, not least in relation to some of the egregious delays which have occurred. I cannot say plainly enough that there should not have been 4 distinct and separate schemes for delivering financial redress. It is true that recently 2 of the schemes have been merged, so that the number of schemes with which I am concerned is 3, but that improvement is likely to make very little difference to the time it will take to provide financial redress to all claimants. However, to use that ultra-modern phrase, we are where we are, and I, for one, cannot imagine scrapping all the schemes and starting again. Such a step would likely add many years to the period of time which would elapse before redress is paid out to all claimants, and I cannot contemplate that. I do not propose to discuss in what I thought would be a short speech, but seems to be longer than I anticipated, the substance of the recommendations 2 to 16. The details of each of the schemes are set out in section 4 of my report, and the reasoning which underpins each recommendation is set out in section 6. That said, I would like to make 2 points. First, many of the recommendations are directed at the Horizon Shortfall Scheme and the newly created appeals process within that scheme. And accordingly, those recommendations should be viewed and considered as a package and not just individually. I make it clear that I share the view of the Business and Trade Committee that the Horizon Shortfall Scheme is the scheme which is in most need of remedial attention. That, of course, is not surprising, given that it has had to handle close to 10,000 claims, and there may yet be many more to come. There can be no doubt that but for the availability of the fixed sum offer in that scheme, it would have been overwhelmed. Second, recommendations 2, 3, and 5, which apply to all schemes, and recommendations 11 and 12, which apply to the group litigation scheme, are made so as to seek to ensure, so far as possible, that the main processes in each scheme are at least similar or broadly comparable. That leaves recommendations 17, 18, and 19. I have been persuaded that the victims of wrongdoing and the public at large will never be convinced by words from lawyers that financial redress schemes which are administered and delivered by the alleged wrongdoer are truly independent. Furthermore, with the growing appetite which undoubtedly appears to exist for redress schemes to operate without reference to the courts or a formal arbitration structure, it is, in my view, necessary to create a body which has the expertise and capability to administer and deliver redress schemes which are and are seen to be wholly independent of the public body alleged to be responsible for the wrongdoing which has created the need for redress. However, and this may disappoint some, let me stress now that I do not believe that such a body could be created sufficiently quickly to make it viable for that body to take over the administration and delivery of financial redress in the existing schemes. Recommendation 17, if accepted, must be implemented with considerable care and with a clear set of objectives laid out from the start. As will become obvious from a careful reading of my report, there are literally thousands of claimants in the Horizon Shortfall Scheme who are waiting for their claims to be assessed, and some of those, and there may still be more than 300, have been waiting for 5 years, and there is still no end in sight. There are claimants in the overturned conviction scheme whose convictions were quashed by the courts in 2020 and 2021, who are still to be fully compensated. And there are still about 150 people who are parties to the group litigation who are waiting for the assessment process to run its course. I do not believe there is any justification for all those persons to be put on hold while a new body is created. As I describe in my report, the existing schemes are flawed, but in my view, the schemes can be improved significantly, says he, if my recommendations are accepted and implemented. Let me say a word about recommendation 19. As I have implied, the phrase restorative justice was new to me when I began my work on this inquiry. Yet as the work of the inquiry gathered pace, and particularly during the course of the hearings last year, the call for measures which are associated with the umbrella phrase restorative justice became louder and more persistent. The Post Office and Fujitsu embraced the concept with what I might describe as varying degrees of enthusiasm. I was left with the impression, however, that they would both at least consider what sort of package of measures would be appropriate. Yet to date, I have heard nothing, hence the need for a specific recommendation. In my view, departmental involvement in this process would also be very welcome. I have said nothing about recommendation 18 as yet. Without doubt, I found the issue of financial redress for family members to be very difficult to resolve. I have been acutely conscious of the difficulties which family members would face if they were seeking to pursue claims against the Post Office, the Department, or Fujitsu in the courts. That said, I am also mindful that these schemes are not and have never been constrained by established legal principles. Accordingly, I have reached the conclusion that fairness demands that financial redress should be provided for those family members who have suffered serious adverse consequences as a result of the treatment meted out to their loved ones. I'd like to conclude by paying a special tribute to all those who have helped me compile this first volume of our report. They are here, they are in this room, they are all the lawyers who made compelling submissions to me. The inquiry, I trust, has gone smoothly to date, and in huge measure, that is down to you and not me. Thank you very much. Enough. It's time for lunch.
You're watching Sky News today, live from the Oval in South London. That was Sir Wyn Williams outlining the findings of his first report into the Horizon IT scandal as a result of the inquiry. I'm pleased to say I'm joined now by Seema Misra down here at the Oval. Seema was a sub-postmistress who was convicted and jailed when you were pregnant, Seema, which will jog many people's memories. We can revisit all that stuff, but I know it was terrible for you. But primarily, I'd like to begin by asking you what you think about what you've heard today.
The report is really thoughtful. Definitely lots of thought had been gone in there with lots of suggestions, which is really good.
Yeah. What's in your experience of trying to get compensation?
Compensation scheme itself, it's not just myself, because we deal with so many other postmasters as well, and we hear their stories. It's like a torture.
Yeah, because there have been 4 different ways for people like you to try and get some compensation that they deserve. it sounds complicated to the outsider. We've just heard Sir Wyn there say the whole thing has been flawed. Is that what you think?
Definitely, definitely.
Describe the experience of going through it.
It's just like you have to prove yourself again and again, like who you are.
Yeah.
Even after winning GLO, getting your name cleared, again then you have to prove yourself, which is terrible.
So it feels like a recurring nightmare.
It is recurring. Revisiting it again and again, it doesn't help at all.
No. And I know you have had an issue yourself with a lawyer who was representing you. You thought they were offering pro bono assistance, and they then sent you a bill.
I know.
Yeah, which is something you're going to have to deal with. So I guess what I'm getting at, Seema, here is, when is there an end to all of this for you? Do you know?
When the accountability is done, hopefully then that will be the end to it. The accountability need to be done. So actual culprits need to go behind the bar. So hopefully that time brings some sort of closure.
Yes, and we know the Metropolitan Police are looking at this now, but they're not going to start acting upon that until the whole inquiry is finished. This is the first of two reports that Sir Wyn has talked about today. Let's just go back to when this all happened. Of course, Horizon was rolled out in
2000.
2000.
Yeah.
The convictions started happening soon after. It's been such a huge chunk of your life,
I know.
Hasn't it?
20 years for us. We took over the post office in 2005,
Yeah.
June 2005. So 20 years and one month extra. So it's taken 20 years of our life and still hasn't been sorted.
Yes, and that is the experience of not just hundreds of others who faced conviction. We're hearing 10,000 people and their families as well. It's the worst miscarriage of justice ever.
It is the worst. When we took over the fight, we knew it's going to take some time because we're fighting with authorities here, but we didn't expect it this long.
Talk to me about the experience, and I know you've talked to colleagues of mine, Wilf and others, about the experience of being sent to prison when you were pregnant. You already had an older son as well. That must have been the lowest point you experienced. I
never thought I was going to come out alive from there. We saw in the report as well that 13 people committed suicide. I would have been one of them if I had been pregnant. I would be instead of 14.
Yes.
So it is painful. It is really, really painful. With so many people lost life over the scandal as well. Our thoughts and prayer with their families and family.
Yes, you're right. That is something that we didn't know before, is that 13 people took their lives. So Wyn has put in his report, he thinks as a result of this, another 59 others contemplated it. When you heard that, how did that make you feel?
It's very painful because I was one of them thinking to take my life anyway, So it is very painful. Post office, they torture you that to the level that there's no other choice left.
When Sir Wyn says he wants the government, the post office, Fujitsu to get their heads together and quickly and come back with an agreement on how to deal with compensation in the autumn, what do you think?
Definitely, it's a really good suggestion with the cut-off as well. So hopefully they will feel some pressure and act on Sir Wyn's suggestion and act on them. Do
you think, Seema, you'll ever get the justice, the compensation that you think you deserve?
It needs to be done. It needs to be done. We won't give up till each and every single person got the full compensation.
Yeah. And I appreciate you're one of a handful of people who talk to us journalists. There are hundreds of others who understandably don't want to engage with this process. Do you empathise with that?
Definitely. I'm speaking here, I'm not just speaking for myself, it's like a whole sub-postmasters and the family. We can understand some people don't feel comfortable, which is fine, but at least the story is out, public support is there now, so we will get this done, sorted soon.
Seema, really appreciate you talking to us. Appreciate this is the first of two reports. The process isn't quite at an end yet, but thanks all the same.
Thank you.
OK, let's hear more now from the inquiry chair, Sir Wyn Williams, who is now calling for urgent action to be taken to ensure that all victims, like Seema, receive full and fair compensation.
The picture which has emerged and which is described in my report is profoundly disturbing. In summary, what does that picture reveal? Many thousands of people have suffered serious financial detriment, and for a sizable proportion, that detriment subsists. Many people have inevitably suffered emotional turmoil and significant stress in consequence. Many businesses and homes have been lost. Bankruptcies have occurred, marriage and families have been wrecked. Between 2000 and 2013 in England and Wales, and for some time after 2013 in Northern Ireland and Scotland, postmasters and others suffered the trauma of criminal prosecution, conviction, and punishment. And for some, punishment meant lengthy periods of imprisonment. I received reports that some people held liable for shortfalls became ill as a consequence. Tragically, I heard too of people of whom it is said that they were driven to take their own lives.
I was Inquiry Chair Sir Wyn Williams. I'm joined by Alice Porter, our correspondent here. Some of the words leap out there: profoundly disturbing, trauma. But one word he used quite a bit was flawed. We know the Horizon IT software was flawed. The response to it being flawed, well, that was flawed as well because of the convictions of people like Seema Misra, who we just spoke to. And now Sir Wyn Williams pointing to the fact that the redress schemes, 4 of them, well, they're also flawed as well.
Yes, and it was interesting. I think some people may feel it doesn't go far enough because there are people like Sir Alan Bates who are really hoping that these various schemes were taken off the government and that there's an independent body set up. We're not quite getting that picture from this inquiry. What we have got is that we've got Sir Wyn Williams saying that these existing schemes, whilst they're flawed, they should still be in place, and that is significant. But the reason why he's saying that is because of the amount of time it would take if this was then taken out of those three government schemes. If they were taken out of their hands, it would take even longer to get the money into people's hands who are fighting. So I think while some postmasters may be disappointed by Sir Wyn Williams, we get an understanding of why he's done that in the way he has.
Yeah, he's talking in the future, isn't he, about an expert body to deliver redress because of the failures of this whole setup to do exactly that. But people like Seema and others, they can't wait for that body to come into existence. They need that compensation now.
Absolutely, and I think what is also interesting is we still have yet to hear from Fujitsu in terms of, it was last January that Paul Patterson, its chief executive for Europe, said that they had a moral obligation to provide money towards compensation. That money is still not yet on the table, despite there having been talks with the government. So I think there's certainly what eyes will be on them. We haven't yet heard from them as to what their response will be to this inquiry's report.
Yes, look, Fujitsu, the government, the Post Office, all mentioned in the report, of course, but in particular when it comes to an approach of restorative justice, something Sir Wyn acknowledged that was a novel idea for him, and he said that there have been varying degrees of enthusiasm for that from the Post Office and from Fujitsu, pointing the finger at them, saying, well, they need to do more in that regard as well, not just on compensation.
And I think something that will make that very difficult, particularly for the victims, is I was surprised by how much further this volume went. Bearing in mind we have the second volume, which will much more likely to point the finger of who knew what and when, and we were expecting that later in the year. So we weren't necessarily expecting this in this report, but Sir Wyn Williams did say that he is satisfied that staff at the Post Office and Fujitsu knew that there were problems with the Horizon software and that the Post Office maintained the fiction, which was the phrase he used, whilst prosecuting innocent men and women up and down the country. You've got that in a report as well as that as a lived experience by thousands of men and women. Trying to get people on both sides in a room as part of restorative justice will be incredibly difficult.
It sounded like, in his summing up of how the various compensation schemes have worked, that those postmasters and postmistresses making lower claims were getting pretty much what they asked for. But when there was more than that, then that was what was causing the problem. And it's going to take, he admitted, even longer for some of those claims to be sorted out, maybe not even by the end of next year.